Hi, my name is Pat. I've been caregiver a few times in my life. I was a full-time live-in caregiver for my mother and an unpaid part-time caregiver for several friends. My experience being a caregiver to friends with no close family members has taught me the importance of advanced care planning and knowing the difference between a living will, a power of attorney, and substitute decision maker. When one of my friends in her late 70s started to show signs that her health was deteriorating, I stepped in as her part-time caregiver. We'd been friends for over 30 years, and she only had two distant relatives who were not really involved in her day-to-day life. She was hospitalized several times. She had several surgeries, serious surgeries. As she struggled, together we visited several retirement residences in Toronto in anticipation of her future needs. Toronto was where she wanted to stay. She didn't want her relatives involved at all at this point, but she had no will, she had no power of attorney, and nor would she discuss advanced planning with anyone, not with her doctors, not with me, not with home care providers. The situation really reached a crisis when, following a psychotic episode due to incorrect medication use and she was dehydrated, she was hospitalized again, and the doctor wouldn't release her to live by herself. At this point, she reluctantly agreed to create a power of attorney and a will, but she misunderstood them to be one and the same, and so she gave the power of attorney and the role of the executor to the one distant relative whom she remained regular contact with, if you will, but over the phone only. She thought that I would continue to act on her behalf regarding medical and personal care because I'd been doing it for years. In other words, she thought I would continue to be her substitute decision maker. She couldn't understand that a caregiver is not necessarily a substitute decision maker, that unless they're legally assigned the role with the proper documentation, it just isn't so. The doctors wouldn't talk to me any longer. They insisted on speaking only to the man who had been given the power of attorney. So he made the decision to move her to a home, which was almost 500 kilometers away, close to his home, where her only contact was him. It was determined that this distant relative that she'd named as her power of attorney had financial problems of his own. His son was in a real crisis, and he'd already spent most of her money to resolve his own personal problems. He also was in the process of liquidating all of her assets, including selling her condo in Toronto. She didn't want that because she had retained that sort of as a stopgap. She could go back to it if things didn't work out. It became clear, though, at this point that it was his intent in becoming power of attorney right from the beginning. She was devastated. She passed away a broken-hearted woman. There really wasn't a medical reason for this. She just kind of gave up. If you're a new caregiver, please, you have to do whatever you can to protect yourself and to protect the person that you care for. Engage the help of whomever you need to help educate them about advanced care planning. Make sure that they understand the difference between a will, a power of attorney, and a substitute decision maker. Use various scenarios that they can relate to help determine the directives on how they would wish someone to act should that situation arise. Only in this way can you really assure them that their wishes will be carried out. Clarify who's expected to make the medical decisions, the personal decisions, and the financial decisions. If you're expected to make medical decisions, should they be unable to do it for themselves, make sure that a proper document is drawn up, signed and witnessed, outlining clearly the extent of your responsibilities.